My name is Amy Meyer. I'm on the training committee. We do read those evaluation forms you guys fill out and try to implement your suggestions. One of the most requested topics has been on client interaction. So we had a part 1 on that on December 4th with Professor Stringfellow Ote, and today we have a panel of experienced LADL attorneys who are going to give us some more specific practical advice on trauma-informed practices that they've developed over the years. Our panelists are Chistina from the Anderson firm. Hopefully we'll be arriving soon. Dennis Smeal from the Firth firm, Henry Parks from the Metzger firm, Rachel Ewing from the Ewing firm, and Zane Zeidler from the Lee firm. All of them were chosen based on their track records of being able to connect with clients from different backgrounds and thereby get results for those clients. We have 2 handouts today. Please make sure that you have the correct and current version of the article, Habit, Story, Delight. We had a couple in the beginning that were maybe missing some pages from the front. It's an article on tools for public interest attorneys that you should read at your leisure. I found it very informative. Then we also have a worksheet that you can fill out with any useful takeaways from today's training. Quick disclaimer, our panelists are going to be talking about their own experiences and strategies that you can take or leave depending on whether they work for you. And your firm may have some policies that overlap with some of this stuff, so be sure to talk to your supervisor or firm director if you have questions about that. It's going to be a Q&A format. I have a list of questions that I prepared with a lot of your input, but also feel free to raise your hand with any other questions that you would like the panel to address. We're going to divide this into 4 sections based on the stages of the proceedings and the stages of the attorney-client relationship. We'll start with detention, then move on to adjudication, disposition. Then we're going to talk about review hearings and everything after dispo. And last, we're going to cover outside the courthouse, reaching out to your clients between hearings, time management, self-care, etc. So if you can, try to keep your questions to the topic that we're on, and I'll try to get to as many of them as I can. All right? So, starting with the detention hearing. And any of you feel free to answer as many or as few questions as you have answers for. What is your method for introducing yourself when you first meet a client, and how do you build rapport?
Basically, when I first meet a client, let's say, so this is at detention, right? So when I first meet a client, I will introduce myself. I'll say that I'm an attorney and I'm going to be appointed to represent them that day. And then I usually try to find a confidential place to speak with them, ante-room hopefully, if it's available. And then my first question I ask is, have you ever been here before? Or actually, I make the assumption of like, you haven't been here before, right? And then we go over the whole entire process. At the detention hearing for me, I talk more because I think it's more important for me to give them the information and set it up for them. So I tell them why we're here, why the department has intervened. I also will walk them through what the courtroom looks like. We have to remember that when clients come in, although it's our 5,000th client that we've met, this person's never been in court before. And so it's very important, I think, for you to try to give them a picture to put them at ease. A lot of times, at detention, as everybody knows, we'll get someone who's very upset, that's crying, and it's important to try to hear them out, try to kind of listen. But I think at the detention hearing, for me at least, I do a lot of the talking just to kind of set the scene for them so they understand what's actually happening before they get inside the court.
I agree with everything that Chistina just said. I think that the other piece of it for me is acknowledging that they're going through probably the most traumatic event in their life, you know, having their children removed from them. So I try to acknowledge that. I tell them that that we're a team and that we're going to be working towards their ultimate goal, which is, of course, getting their children back in their care as soon as possible. And I also talk to them just briefly, more later, but briefly about what can and cannot happen at that particular hearing.
I would join in those comments that I think, particularly at the detention hearings, I think people are often surprised because they don't get to talk. They don't get to, they can't address the court, or they're not going to be allowed to address the court. And really, whatever defenses they have are not likely to be heard that day, and so that is often difficult. I will try to introduce myself, and I'll try to make sure that they can at least hear that we're separate from the social workers and all the other people who they've spoken to about their case. We're not the judge, that we're not judging them, but that we are court appointed. I make sure that they know that the judge has appointed me and asked me to come out there and speak with them and to explain to them what was going on. And then I will stress on the detention hearing that their judge, who is obviously up there judging everything, is going to be caring about how they look and how they act. And the judge is trying to figure out what happened and what should be done about it. And I'll just keep coming back to that. Those two things. One is what happened, and secondly is what needs to be done about it, or what the judge will want to do about it. And we'll try to discuss those things, and it sort of grows from there. Sometimes an explanation that even if you're a victim, the court doesn't care. It's still a problem, they still have to address it.
For me, I think the detention hearing is a good point to really connect and make that point that you understand that they're going to do something. That every single person that comes to our house or comes to our courthouse, something's bad happened to their family, whether they're a non-offending parent or not. Something has led them to this courthouse. And I think a really good way that I've made a conscious effort of addressing that is the first thing I say to my clients is, how are you doing today? And that gives them the opportunity, and most of them will say fine or good, and you know that they're not doing fine or good. And I think that opens it up to say, look, I understand that being here is hard, being here is really difficult, and that this is, the first hearing. This may be the hardest hearing for you, because this is when it takes the least amount of evidence to find something true against you. But this is a process, and that we're appointed to represent you and only you. Stress the duty of loyalty and confidentiality to them. But I think it's something really simple, but something that I've made a conscious effort is the first thing I say to them when we find a place to sit is, how are you doing today? So try to break down the barriers that they've built up throughout their life. A lot of these people have dealt with trauma throughout their lives. A lot of them were previous foster youth themselves. And so I think just a simple question like that may allow you to have a deeper connection at that detention hearing with the clients.
So some of our clients see us as part of the system that's taking their kids away rather than their advocate, and some of you touched on that already, but how do you respond in those situations, especially when you get a direct accusation, or when they just say, you guys, as in you and the social worker and everybody else are doing this to me?
I think it's important to note that most of the time when they say that, they don't actually mean that. It just comes out that way, and I think we all hate social workers, so we sometimes take it personal. We have to make sure that we don't take it personal when they say that. And you just, when you get a chance, and with me, I just intervene and be like, I just want to make sure that you understand that I represent here. I represent you. I am your advocate. I'm on your side. I don't work for the department. But I think a lot of times we take it personal. Sometimes we'll be like, no, I'm not them. Stop saying that. Instead, just realize a lot of times I think most of the time they just say that because it just comes out of their mouth that way. And it's important to just, on a side, just say, we'll just note it for them so they understand, but just don't take it personal, I guess.
And I think, going back to what Mr. Parks has said was about really explaining the roles in the courtroom, and taking that initial step and trying to explain everything at the detention hearing. Maybe we'll address that when it comes up later, explaining that I'm representing you, only one parent, that there's a different attorney from a different office for another parent, and just really explaining the roles, and that the trials attorney is separate and DCFS is separate as well with county counsel. I think trying to make sure that they understand the different roles could really avoid those issues in the future.
And for those of you just joining us again, feel free to raise your hand if you have any questions that you want to ask the panel. I will try to take your questions first. So How about connecting with clients who have mental illness or developmental delays? How do you kind of assess where they are and meet them where they are without being condescending?
No, go ahead. I'm trying to figure an answer.
You know, at the detention hearing, that's probably the time I try to take the most to assess what I'm dealing with in terms of my clients, whether or not they're chronically mentally ill, or whether, you know, they're so angry that they can't, you know, really engage with me effectively, or for the client who has delays. Sometimes I will ask some questions while they may not want to give me a whole lot of information. You know, I might ask about whether or not they have any dealings with regional center. I might do things like ask if they've ever had an IEP, kind of broad things, and depending on how receptive they are to giving me that information, I'll get more specific. I've gone as far as to ask them, depending on, for example, where they live, you know, have they had an evaluation? Did they participate in like an upfront evaluation with the department? So I'll just kind of pick around to try to gauge where they are and how they're feeling, and if they're going to be open about that. If not, then we'll just go through the interview and the discussion, and then, but I'll make a note in my file that I have some concerns, and I'll come back around and we'll talk about that later.
It's difficult to talk about because each case and each client is so different, and I understand that we don't know what we're dealing with until we actually, you know, confront the person or sit down with the person and try to strike up a conversation. It's such a broad range of behaviors that we have to deal with. So I attempt to not make any judgments about them, you know, and sort of get myself out of the way in that. And there are some checklists, some things that we want to cover, and you'll have that in your mind, you'll have it in your file, and you'll go through that. But you have to pretty much meet your client on the level that they're on, and find language that they can sort of relate to, and to be able to discuss the things you need to discuss. And so that'll vary, but I guess there can be checklists as to what you need to cover, and you want to make that assessment. At the same time, you're trying to develop a rapport with them. You're trying to, again, assess their capacity to help you come up with a defense, come up with a plan for the case, understand what they want to accomplish out of the case. So it's kind of it's an art, but it's also an opportunity. I mean, it's one thing that's pretty interesting about the work we do, you know, because you can sort of get in these people's lives without subjecting yourself, you know, to that. I mean, you can, if you like to be nosy, you know, you can get all this information from people, and take it as a challenge.
And just to note also, I think last week somebody asked a question of how do you do this when you're being pushed for time, when you have a bench officer saying we need to call this, and you're trying to figure out what's happening with your client. Many times I will tell my client, like let's say in this case scenario, I would say, I'm sorry I can't talk with you more. I'm going to assign an investigator on this case to come out to you, meet with you, in order to get more information. Because sometimes we don't have that much time, but we do have resources. We have our social worker investigators that can go out to the home and do another additional assessment as well.
And I think sometimes it's also just letting the client feel like they're being heard at least, and just listening for, let them actually get what they need off their chest, even if it's not related to what you're talking about. You listen and then you redirect, and I bet, we still need to do this paperwork because the court's calling for us. But I hear you about that concern, and we can address that later. And just trying to show that you are there and you're listening and you're not just trying to get this paperwork done.
Dennis, I'm so glad you could join us. I know you have an answer to this question about connecting with clients who have mental illness or developmental delays.
So I just came from that situation. And I think that, I'm sure that they've covered all of this perfectly, but what I would add is you have to really put the effort in. You have to really put the time in. You've got to know that you can't just, you're not going to be able to do this in 5 or 10 minutes. You're going to have to call a supervisor or call one of your senior ones and say, I need some extra time. Can you come and do a case for me so I can give this client the time they need? And there's no time like the present. You've got to do it at the detention hearing, because that's when you have to get the information. To me, that's the most important hearing. And it's also, you don't get a second chance to make a first impression. So all those things your mom told you about people is true. And I think that the way this goes most seriously off the rails is when the attorney feels that they're dealing with mental illness and they decide that that means there must be a guardian ad litem required. So just a couple of tips for the people that have never heard the guardian ad litem training. Irascibility is not incompetence. And our clients are having the worst day of their life, and if they are normally kind of walking through life with a little bit of a chip on their shoulder, when they come to court under these circumstances, they're going to be wildly frustrated and just completely off the chain angry with the whole world, and that's going to include you. That doesn't mean they aren't capable of understanding that they're here in court and that their child has been taken away, and that doesn't mean they're not going to be able to assist you in preparing a defense. You may have to dig for the defense. You may have to ask 100 questions. You're definitely going to have to be super curious. You may have to talk to friends or support system that they brought. It's going to take a lot of time, but what you almost never need is a guardian ad litem. Please make sure that in your heads that's a very, very last resort. It's for people who are in comas. It's for people who are coming to court and they won't look up, or answer a single question or make eye contact, even though you have really tried some kind, loving care. That's the situation for guardian ad litem. Anywhere in between, please make sure you talk to your supervisor.
Anybody have any questions on that first interaction or detention hearings that they wanted to put to the panel? Or move on?
So moving on to adjudication and disposition, how do you respond to clients who want to dictate your legal strategy?
So what I do, I want to see where they're at first. What are they actually saying? If they're asking me to file some weird motion that doesn't make any sense, if that's the case, then I can see that they've looked into the law a little bit, right? They've probably researched a little bit about dependency, and they think they know how things are supposed to go. So in those cases, for instance, I'll send them case law, or I'll send them statutes. I'll actually have them read upon the law so they feel like we're working together, and I'll say, this is why we can't do this, and I'll send them stuff. If it's something else where they just want me to call the kids to testify and I don't think it's in the client's best interest, I'll tell them that, but then if that's what they really want to have happen, I'll tell them what's going to happen. And if it's relevant, if I can do it, if it's relevant to the actual issue, I'll call them to testify. But I'm not going to do anything, of course, like I'm going to file frivolous motions, do things that aren't legally proper. I think some of our clients, sometimes, unfortunately, you need to do things and this is my opinion, you need to do things that show that that they could trust you, and sometimes that's at the adjudication. So for instance, I might have a client and I say, if we do this, this is what's going to happen. I really don't recommend it. This is what's going to happen if we do this. And they'll say, no, that's not true. All right, we do the adjudication. I still try hard. I do the way that he wants me to do it, he or she, and it ends up in a bad way. But then at that point, they're like, okay, yeah, you were right. So what do we do now?
We're having a conversation, but I think that for me and the type of person I am, I don't necessarily think everybody can pull this off, but I let them know that I'm the person captaining that ship, that I'm the person with the education and the experience and the knowledge. And if they have some question about my ability to try to get them the best result, which I always see as getting, their children home, I agree with Chistina. I try to give them as much information about the process as I can. I don't know that I've ever given them case law, but I absolutely give them information about how dependency works. And then we sit down and I talk to them about why we're going to do certain things. And I say we're having a conversation because there have been times when a client has said, you need to call my son because my son is going to say X, Y, and Z, and I had no intention of calling his son because the statements in the report were just awful, and the client, depending on the relationship that we've developed, may have convinced me that, yeah, I do need to call the kid, and I'm going to call the kid. And sometimes, I'm not going to say it all the time works out great, but it absolutely does kind of change the flavor of the hearing, and it does tremendous things for your relationship with your client. But I absolutely would never do anything that I think would torpedo my client's case.
Yeah, that's, I guess you want to involve your client, and it comes back to understanding your role. If they're the client, you're the attorney. I will often stress to them the fact that it's part of my job is for them be able to try to make some predictions about what will happen with these facts in this court, in front of this judge, what's likely to come out about it, and try to explain why I'm arguing what I'm arguing, or why I'm not going to call a particular witness that they might think is relevant, or delve into a certain issue that they want everyone to know about. I use a couple of metaphors that sometimes my clients can relate to. One which is that I'll tell them that I'm the coach and they're the point guard, and that we're going to huddle up, come up with a strategy, but then they have to execute it. Like if they're going to testify, they're going to be on the court, and it's going to be on them if they delve into these issues or not, and if they're convinced that they can score by doing that, that's not the play I call, and make them understand that. Another metaphor is just that we're on a trip and we get an Uber driver and we don't like the way that he's driving. Well, we can't just grab the wheel, if we're a passenger in the car. So if I'm the driver and they're the passenger, they got to stay in their seat and let me drive, and sometimes that leads into a conversation about if I'm the right attorney, or if there's a need to change attorneys, or whatever it is that they're not feeling heard about. And oftentimes you can sort of, work through that so that they have an understanding of the limits of this case, that often that there are issues they want resolved that aren't going to be resolved that particular day. There are conflicts with other family members, or life issues that are not relevant to that hearing that particular day, and they can, again, get behind you and help you and allow you to make your arguments and actually support your arguments as they're presented.
I always tell them it's kind of like when you go to the doctor. The doctor tells you need an operation, and you get to choose whether you want to go get a second opinion and whether you want to say yes to the operation or say no to the operation. But once you say yes to the operation, you can't tell the doctor what what size scalpel to use, or where to make the incision, or what to take out, or what to put in. That sometimes works. The technique that I use, and I'm sorry I'm boring a lot of people who are at the last training I did, but you just take a blank piece of paper and you say, first I want to hear everything that you want me to do, everything you want done here, and I'm going to write that down. And you just start writing it down. And pretty soon they're going to start repeating themselves, and so you go back and you say, no, see, that was number one, that was item number one. Anything else, anything else. And I've never had it take more than 10 minutes. I've never had them have more than 8 items. And then it's all down there. And then I go through them each and I say, okay, I'm not going to do that, but what you're really saying is that, you know, you want to be heard, and so I'm going to do that in this way. And then 2 and 3, we'll get back to that later. 4 and 5, here's what we could do. And then now, okay, I've got everything that you wanted done. Now I'm going to tell you what I'm going to do. And I'm going to put that list right next to it. And sometimes I've been known to actually look at my list and say, okay, I have a standard rule that I insist that all my attorneys follow, and that is, don't ever let your client be a better lawyer than you are. And every now and then, when I look at my client's list of how they want the trial to be presented, and I look at my list, I find myself woefully inadequate. And, you know, I step it up, or I try to incorporate what the client is saying they want.
I think at the end of the day, like we're all saying, it's just communication. It's just, you just really need to spend the time and ask open-ended questions and figure out who your client is.
So some clients, of course, talk back to the bench officer or otherwise act out in the courtroom in ways that can hurt their case. But of course, trying to stifle them can damage the attorney-client relationship. What are your strategies for, we could call it compassionate client control?
I tell them at the outset that what to expect in the hearing and what type of conduct is going to be tolerated in the hearing, and I also tell them what the consequences are going to be. That if, for example, the bench officer is upset with what they're saying, or they feel anger, and I go down to it. If you're a big black guy, people feel intimidated by that, and I just break it down to them like that. That you can't be behaving that way in court, that if there's something that they want to get across to the bench officer, that I will do it for them at the appropriate time, but that while we're in court, they have to be respectful and keep their comments to themselves.
And similarly, I do the same thing. I'll tell them when we go inside that imagine it being like a stage, and we're the actors, and the judge is the audience, and they're watching you. They're making decisions sometimes based on just unfortunately how you look when you come in. And I think everybody here has had a family law case. I'm guessing one of those crazy family law cases. With those cases specifically, I'll tell my client, I'll say, when you hear the other parent's attorney making arguments against you, I just sit there calmly. I just realize I'm going to get my turn, because when you're grabbing my hand, you grab my hand, if you're tapping me on the shoulder, if you're whispering in my ear, that's actually going to hurt you. And so if you're calm and I'm making my argument, and then you see the other parent doing that, guess what? You're the one that's going to be winning. So I think, again, it's just, I don't know, setting up the stage, letting them know what it looks like before they get in.
And I think if they start going off in court, you really have to step up at that time and take some action to try to calm them down. And I think a good way is slow it down. Just ask for a moment, ask for a second to talk to your client. If they're sobbing, ask for a moment for them to go outside and collect themselves. And usually most bench officers will give you that opportunity just to reset, and then you can explain to them how this conduct is only going to hurt their case going forward.
Yeah. Assuming you have some sort of rapport with your client, and something goes down in court, and it's either somebody says something or it gets to a point in the hearing where they decide to sort of grab the wheel and start saying stuff and doing stuff. Yes, I would normally try to stop them. You want to get between them and the judge if you can, and if they're on a point that you want to say it for them to the judge that your client is unhappy with or indicated ruling and ask for a chance to speak to the client. Then when you get alone with your client, you have to figure out if it's emotion or if it's tactical. Because I've had some clients who go off, but then when you get them out the side, you can tell it's just a tactic. You know, that they think they're being effective, or they think they're communicating something that they really want people to see. You know, and it's not that they've lost control. They really are in control, and they're choosing to go down that path. You know, other clients are overcome with the emotion, and they just need to sort of absorb the moment, you know, so that they can get beyond that emotion and get back into the hearing.
Another thing that I've observed a lot is, so you settle the case, your client signs their waiver of rights, and then it's 2 hours or more before the court calls the case. But when they call the case, you know, you think it's all under control, you just go grab your client and bring them in. And you don't even notice that they're trying to go, you know, you just don't notice. So then you're sitting there and you see your client, and all of a sudden it's like a teapot. And it's, wait, is that boiling? and then you need to, and sometimes you think, well, okay, whatever. But don't say that, because what I've learned is that sometimes they're having second thoughts about what they've done. Sometimes it's about you, and you don't want the judge to think it's about disrespect for the judge. So I've developed this really great 5 words. I think it's 5 words. 6 words. You don't have to do this. I just whisper in their ear, you don't have to do this. Do we need to go back outside and talk more? And you know, sometimes that develops, that results in a big breath and a, no, I'm fine, I get it. Or sometimes I just have a silly question. Like, you know, I reread it again and it says they're going to take my children away and have them adopted. You know, it has that language at the bottom. And I explain, no, you know, and may I have a moment, Your Honor? And I don't know any judge that won't give you that moment. And you take it and you explain to your client what it is. But do always respect them. When they are upset, they're upset for a reason. And imagine they're your kid or your mom, you know, and they're having to deal with a scary professional on the worst day of their life, and you know they're scared and they're sad and they're frustrated, and you know then maybe they get angry too. But you know you're getting to go home to all your fabulous families and come back to your fabulous supervisors and firm directors who love you and respect you, and you know just want you to do well. So remember how great your life is and how difficult their life is on that day.
And can I just make one more comment? I think we need to, and I'm guilty of this too, I think a lot of people are guilty of this. We need to remember that, again, our clients do not, they don't know what to really expect, and a lot of times we forget to tell them what to expect. So they go in, they're sitting there, here's this person at the end saying all these negative things about them. They're like, wait, hold on, this isn't true. And then minors counsel is joining with that, and they're like, wait, hold on, why isn't anybody defending me? And they don't understand what's happening. And that's why I think it's really, really, really important to let them know that this is going to happen. That when they go in, they're going to say really bad things about you. But you know what? You're just going to be cool, calm, collected, and I'm going to get my chance. And don't worry, I'm going to fight for you. But you need to set the stage for them, because otherwise you'll have a much higher chance of your client flipping out during any hearing.
You know, one other thing that I have found really helps is giving your client a pen and paper, and you can tell them, let me know, you know, what's going on during the hearing. Write me some notes and let me know what your concerns are if you have any questions or whatever. And they'll do that, you know, because they're paying attention to every little thing while you're trying to, you know, cross somebody.
Anybody else have any questions on the adjudication disposition portion? Yes,
Something Dennis said that I wanted to kind of bounce off of. He's so right. Sometimes they're sitting for like 2-3 hours after you've signed something. They showed up on time at 8:30, and they're just waiting all day for the case to be called. It's helped a lot to like say hi a few more times before you go in there. Like if they're just sitting there, don't walk past them and not look at them. Say, hey, you know, this is what's happening. We're still waiting on one person. Or hey, it's looking like it's going to be later in the day. I'm sorry. Or hey, I know it's hard to be here, but you know, we're trying to move along as fast as we can. Thank you for your patience. And they usually really respond well to that. And they're like, thank you, I know you're trying.
And you know, neurological studies have proven, You were waiting for me to bring that. When's he going to bring that up?
Right.
Neurological studies have proven that you are 75% more likely to have a positive, your client is 75% more likely to view the interaction as a positive one if you approach them with a smile. And please, 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 you guys don't even realize it. I don't realize it half the time. I'm coming off of where I just came from. I'm not into my next client yet as I walk up to them. I'm still, you know, pissed off that the judge is yelling at me or that the judge is dictating what order I'm going to talk to my clients in. And I look and I walk up to them, and if I still have pissed off face, they're going to like, their anxiety is just going to go from, you know, 8 to 15. So always, please, just summon up that smile. Take that second, you know, put that smile on. Greet them. Let them know that you're so happy to be able to help them, and you know it'll get you off to a great start every time.
Saw another hand in the back. Yeah.
Hi. Also, to touch on the no contest pleas, I find it to be, especially with our Spanish-speaking clients, through trial and error, I found it to be really helpful to, right before we go in, so we can say, okay, the judge is going to repeat everything we've already went over on this form. It's no different. There's nothing added to it, just to reassure them, because when it's coming from the judge, it's very scary and intimidating, you know, and especially when they throw in all the adoption stuff, and it's just very confusing sometimes. So I think that it's really helpful, especially like you said, if they're waiting all day before you go in, to take just a couple minutes and remind them, like, the judge is just gonna say everything, because sometimes they think you're trying to trick them. A lot of them don't trust us yet. So anyway, I find that to be helpful.
Yeah, Lloyd.
I also think it's sometimes helpful, especially in cases that really are an egregious abuse by the department, just to say, I am so sorry that you've been going through this, or I'm so sorry that you're here, I'm so sorry that this has happened. I also recently spoke to a client who had lost a child. It was not an F case, but it was an underlying issue in the case because she was experiencing a lot of grief. And I said to her, you know, I just want to say I'm so sorry for your loss. And she just broke down crying. Like, sometimes it's everyone in the case just gets so used to just reading the reports and let's get through the paperwork and da-da-da-da, and we'll talk about the legal issues, but just to sort of be human about it is helpful.
Yeah, I had a situation just like that when the mom started crying and said, "You're the first person who said that." You know, they had had a child die. It doesn't matter if it was their fault or not. They had a child die. It's, you know, it just takes a little bit from us to be compassionate.
So going beyond just the review hearings, the rest of the proceedings, how do you approach clients who aren't following your advice?
Well, again, I think it's important, again, not to take it personal. I'm hoping nobody does do that, because sometimes they just won't do that. And I think I always think that I try to be a wall, and what I mean is I try not to display any judgment on my face, because I want them to be able to trust me. So I would just let them know. I would talk to them about what they legally can do, what they need to do to get their child back. And at the end of the day, I mean, if they don't follow advice, they don't follow advice. And we work with what we can work with.
I think it's important to just explain the consequences too. You say, well, that's your decision, but this is what's going to happen, and just make sure to explain the consequences fully to them so that they can make a decision. And I think it's important also to not judge. And I think the reading that we had today about talked about parallel universes and coming up with other ideas of why they're not following or not able to do this. Like, oh, they didn't get into parenting class, they must be lazy. No, maybe there's something else. Maybe that they are dealing with, depression, which makes it really difficult to get out of the house and to do things, and to understand that they might be going through other things, that they're not just ignoring you to ignore you, or they're not just not complying because they don't want their kids back. Think about what these people are going through elsewhere, and just try to explain everything to them so that they understand.
Has anybody ever had a parking ticket that they didn't pay? And a warrant got, the fines went up to like $200, and then they didn't pay it still, because who has $200? And then their registration wouldn't get renewed, and then they had to drive there to get to work, and so they got pulled over for driving on an unregistered vehicle, and then the car got impounded. and then it was $1,500 to get the car impounded, and now it's like, 6 months later, and you now owe $2,000. Well, if you've done that yourself, or you know someone who's done that, that's what's going on. It's that exact same thing. And it's usually due to some form of anxiety. Even people aren't diagnosed with anxiety disorder, have mild anxiety, and can end up doing really stupid things. $63 on day one has now become $2,000 that they don't have, and is going to maybe make them lose their job. So, there's no explanation. I mean, you could read books about anxiety. There's a great one called The Age of Anxiety by Stossel, but you just have to know that what these people are going through has to do with their brain chemistry. And it is, a diagnosable mental illness, and it's also highly, highly treatable. But that's what's going on. It's not, I used to, for years, say to them, so basically you're telling the judge that, your pride is more important than your children, or it's not worth it to get your children back to do this parenting class. I used to actually believe that, and now I know so much more. So just know that they're trying their best every single day.
I think I speak to my clients very bluntly. I also am very clear with them that I believe that the ball is in their court because these are their children, and ultimately the buck stops with them. Hopefully, when you guys are working with them on their case plan, you're ending up with a case plan that's narrowly tailored so that it's going to address the needs of that particular family. But not only that, I mean, the reality is, right, that the department's not going to help them do shit, okay? So we have wonderful social worker investigators that we really need to tap into. In developing your rapport with your clients, you're going to find out reasons why they can't get out of their own way, or why they're not doing the things that they're supposed to be doing. I had to face many, many times the reality that my client was choosing his woman and not his kids. That happens, and then you have to deal with that. Or sometimes they are struggling with some type of mental health challenges, and you got to focus on that first, and then maybe they can get to the parenting. But I try as much as possible to empower them, and also to help them navigate that by using the experts, by using our social workers to help them get into programs that are going to help them.
What do you do when you seem to be having the same conversation over and over? They want to keep relitigating the petition after dispo, or whatever you're saying just doesn't seem to be sinking in.
I tell my clients, I initially tell them, if you're calling to talk to me about something legal that's happening in your case, call me and we're going to talk about that. We're not going to talk about what happened at detention. We're not going to talk about what happened at juris. But if there's something going on in your case that has to do with the courts and something legal, we're going to talk about that. If it has to do with child safety, then I need you to call the social worker, and you guys need to have a conversation about that. If there's something that's happening with services that you need, yes, you call the social worker, but call me, because I have social workers who can help you, and we're going to get past that. But I really try to take control of that and let them know what we're going to talk about and what we're not going to talk about. Their family law thing, unless it specifically has to do with what's going on in our case, I don't want to hear about the wife sleeping with somebody else, or I don't want to hear about that. And I tell them why that's not relevant to what we're doing.
And just this actually would jump back for me, just a point that I want to make at the detention hearing or at the adjudication date. When you have that client that, let's say, wants to complain about something, like about the other parent, or is really upset about all this other stuff that's going on that you can't really help, I I usually talk to them about the importance of actually getting into therapy. That this may be a part of their case plan later on. However, I tell them it appears to me that you feel like you have no support. Is that right? And it's just you're all by yourself, and you need to find support, so we need to get you into individual counseling. And so trying to have them have some type of outlet, because guess what, a lot of people don't have any, a lot of people come in with no support at all, and we are the support, but it's draining. We're not therapists. We can't be the person that's providing them with all that extra support, because again, we're just their attorneys. But trying to sympathize with what they're going through and then direct them in the right direction, I think that's helpful.
Yeah, I try to give my clients some coaching, especially when they call me with the same issue over and over. And I understand that a lot of times they're also calling the social worker, and the social worker is deflecting back to us. They're saying, talk to your attorney, talk to your attorney. They don't want to deal with it. They say, call your attorney.
Your attorney can file a 388.
Yeah. Yeah.
So I don't want them to just kick the end of the road. I don't want them, if we just hang up on them or don't take their calls, then they're back where they started. No one cares, So I try to coach them a bit, and sometimes it's about how to talk to the social worker. Like there's a way for them to ask for help. There's a way that there's a way for them to elicit the social worker's help in their case, but they have to approach the worker with that. And part of it is, it deals with taking some responsibility for the problem and acknowledging that to the social worker and asking the social worker, because they're in their face, telling them what they do wrong. They just need to put it back on her desk and say, well, how can you help me through this? How can you get me enrolled in a program? How can you get, how can I work out this transportation problem or this child care issue? And make the social worker worry about those things. Again, so I guess we just can't, we have to avoid judging our client, and they're judging the situation. Like you indicated before in the paperwork about these parallel universes, these cases, it's like we take a snapshot of the worst day of their life, and we make the whole case about that. And there's a lot of other things that are going on in their lives that get in the way of their complying with these case plans.
And I want to say it's funny because you say that, because we'll have our clients say, "Oh look, I got a job, but look, I got a house now. So can we show the court that?" And it's like we're saying, well, that doesn't matter because the court didn't order you to do that. But that's to them, that's a success. That's showing that they're moving on.
Yeah.
And immediately we're saying, no one cares, And so, I mean, just an interesting thing to point out. Kind of shitty.
And I think that it's important to acknowledge where this, like the circular conversations you have with them come from. And often if, you're going over the same thing, it's like, well, and you explain, well, because of this, well, then how come this? And then, well, because of this, and you just keep going in a circle. That's often a sign of trauma, and that they're unable in that state of trauma to understand how you're explaining it. And it's not because you're not explaining it well, and it's not because they don't want to. Often those circular conversations are actually evidence of trauma, and that there needs to be a different way to explain it to them, or a different way to address that trauma that's causing them to not understand why they're going through the system and why this system is dragging them through this. And that's when you might have to, take it up with, go to do an AR, to have somebody who can do some more social work, connect with some other agency that they're working with. Because that's, I believe, is the cause of those circular conversations, is not because they're trying to be difficult and not because they're not trying to understand, but it's actually an evidence of their trauma that they're experiencing.
You're not going to like this because you're going to think it takes a lot of time, but if you think about the amount of time that you spend having these circular conversations, do a letter. Just do a letter where you lay out the law, what they should have done, what they haven't done, and what you're hoping they will do. And make sure you start with some kind of understanding and you end with some sort of hope. And then you suggest to them that they take that letter to their therapist, or that they just read that letter whenever they can, whenever they're calm enough to do so. So that's number one. I think don't underestimate that letter. And number two is, I agree with Rachel, like totally. I would just add this. Every parent deserves, before their first 2-6 hearing, or at the 2-6 hearing, they deserve to know why what's happening is happening. And I have had clients who have said, I don't know why this is happening. And I ask them a few questions to see if they're the manipulative parent or just trying to make life difficult or trying to hold things up. You know, but a lot of the time they really don't get it. They just have never gotten it and they still don't get it. And you guys are the best of the best. You really are wonderful, wonderful lawyers. I think you're the best crew of lawyers we've ever had in the 12 years of LADL. And so, you know, look at the case with them, take some time with them, and making sure they can look back and see what was the sustained petition, what did the judge want them to do, what were they able to do and not able to do, and why are we still here? And what's going to happen? What could they still do if the judge doesn't terminate their parental rights today? If it's one of those cases where they need a 120-day continuance, parents can turn it around. And I think you'll be shocked at how often you hear, nobody has ever explained it to me like that before.
Anybody have any questions on that? That whole section beyond dispo before we move to like outside of the courtroom conversations with your clients? All right. So
I think perhaps the two most common challenges we have when trying to communicate with our clients in between hearings are either they leave us 20 messages a day or they won't return our calls at all. So starting with the first one, when we're getting just a ton of communication from them or just repeated emails, do you have any strategies on addressing that?
I was actually really able to nip this in the bud when I was a case carrying attorney. I made my voicemail very specific. And I said, when you leave a message, this is how you, in order for me to return your phone call in an efficient manner, please follow the following directions. 1, leave your name. 2, leave your number. Don't assume I have your number because oftentimes I return phone calls from court. Literally, my voicemail was very long. I would say leave only one message. I return phone calls every day between 12 and 1:30, and I will return your phone call within 24 hours of me getting it. So just leave one message. Leaving multiple messages will not increase my speed in getting back to you. It'll only delay it. And that actually helped a lot. And especially when your clients start knowing that you, like with me, that they know that you return phone calls every day, then you never really have that issue. And I just want to touch on one thing real quick. It's on one of the questions that I saw that you had. I think it's for burnout, it's so important to set up boundaries for yourself. It's so important, and there's a way to do it. Each person is different, but there's a way to do it where you're still communicating with your client, because you need to communicate with your client. You need to let your client know what's happening. But you still need to take care of yourself. So with me, for instance, I tell my clients, I will never answer my phone, but I will return your phone call every single day, Monday through Friday. You will hear from me. If the time that I'm returning your call is not appropriate for you, not good for you, let me know when is a good time to reach you, and I'll try to reach you on that at that time. I have constant client communication. Because of that, I mean, I literally now, I'm covering caseload in Department 422. I get 2 phone calls a day now, max, maybe. And it's because people know that I return their phone calls. They know they're going to be in communication with me. They know that they can shoot me an email. I'm going to get back to them. But again, they don't have my cell phone number. I will not give them my work cell, because I know for me that would create a lot of burnout, because I would feel stressed as if I would have to answer those phone calls every day, 7 days a week. And so I know for me that wouldn't be a good way for me to take care of myself. So for me, I've set up these boundaries for me to be able to provide good client representation, but at the same time taking care of myself.
I think it's important to leave specific times that your client is going to either know that you're going to be in the office and can take their call, and or that you have times when you're going to be returning calls. I think that it's important that they have a time frame. They need to know whether you're going to be able to get back with them in 24 to 48 hours. If they leave a message. I don't really care so much about the multiple calls, because I think that's kind of an indicator of their level of frustration or anxiety or whatever, so that doesn't really bother me, even though it's a pain. I get it. And I also ask them to leave me their email. And I'm guilty. I will text with clients. It just depends on their needs. The email helps a lot because you would not probably believe the number of people who are not good on the telephone. They're railing and ranting and screaming. There's just something about talking to you on the telephone that causes a lot of anxiety for them. But on the flip side, they can write, letters and emails, and we can get down to, what the real problem is. And I actually find that I have much more contact with my client via text and via email.
But when they're constantly calling, if they will email, I will encourage them to email, and I'll explain to them. I'll try to give them a window when I am available for them to talk, and I'll explain when I won't be reachable, so that that's not another frustration for them. But I tend to use text and email as well. And I explain to them that that's more efficient, that they can let me know what their concerns are, and I might be able to return a text or return an email more quickly than I can a phone call. But I have different strategies. I do have a few clients that still insist on calling me multiple times a day, and on those, I'll make a point of telling them I won't be able to speak to them once on a particular day, because you'll speak with them, and 30 minutes later, they still want more. They're going to call back, and it just starts over again. And so you have to ration it, and that's what I do.
Can I just say one other thing too, and I actually learned this from Dennis. I used to drive all the time up to Lancaster. It's a 70-mile drive, so it takes a little bit of time. And that was just wasted time. And Dennis was like, what in the heck are you doing, girl? Get on the telephone and talk to your clients. You're just driving in the car. And I used to have all kind of excuses. Oh, I need the file. Oh, I da-da-da-da. And he'd say, no, you don't, because you remember Betty Jane, and you know exactly everything about her case, and you can talk to her.
And there's 3 questions. They only ask 3 questions.
There you go, go.
Oh, okay. Well, they only want to have 3 questions. They're either not getting their visits, somebody told them something that has spun them out of control, or they're having difficulty getting enrolled in some part of their program. That's pretty much it. And once you develop the canned answers to those questions, you're good to go. So you can return those phone calls anywhere, in any line, in any traffic jam. Just return those phone calls. And then, what was I else I was going to say about the phone? Oh. And the way I get off the phone calls and keep them from calling me back right away is I tell them something I need them to do, and I tell them they can't call me back until they've done it.
And actually, for multiple phone calls with me, I'll talk to them between 12 and 1:30, and then they call back at 3 o'clock. They'll call the secretary, and I'll say, let them know, return the phone call tomorrow between 12 and 1:30, because that's like we need to take care of ourselves. We're not their end all, and that's why it's really important for them to get the service. Sometimes it's easy to see some support.
I know a bunch of you have to get back to court, so we can hand out the certificates now, but feel free to stick around if you have